Hello all, welcome you to the course on corporate laws and governance. In this video, we are going to look at the articles of association of the company. First, let's look at the meaning of articles of association. According to section 2 subsection 5 of the Companies Act 2013, the article of association refers to the document that contains the rules and regulations that govern the management of the company's affairs. So basically, if we look at it, article of association talks about the rules and regulation which the company would be following in running its the business activities. So it is more to do with the internal management of the company. So let's see what and all article of association has. It has all the rules and regulations with respect to the appointment of director, appointment of the auditor. It talks about the members, talks about the share capital. It even covers the winding up of the company. So it talks about the different rules and regulations which it would be covering or which it would be following in carrying out the business activities. It also contains provisions for entrenchment. Provision for entrenchment means somewhere down the line the company wants to protect the certain provisions of the article of association, in the sense they don't want to alter certain provisions of the articles of association. They want to make it relatively tough to alter it in order to protect the interest of the company. So for that reason, they would be coming with provision for entrenchment. For instance, a company wants to have a tab on the borrowing capability. What they may do is, in their article of association, they may come out with a rule that if at all the company is going to borrow from outside, then they will have to, this should be approved by one of the directors and the company secretary. They may come with these rules in order to ensure that certain rules and regulations are strictly followed by the company. When this is getting done, the interest of the company is protected. And when we talk about this provision for entrenchment, this provision, when should the company go for the provision of entrenchment? Should they do it at the time of the inception and when they prepare the article of association, or can they do it at a later stage during the after the commencement of the business? This provisions for entrenchment can be done even at the time of the inception of the company. When they prepare the article of association and submit it to the registrar of companies, they can do that. And they can also do it after the commencement of the organization. As such, after getting the registration and commencing the business, they can come out with the provisions for entrenchment. But whenever they are going to come with these provision for entrenchment, this should be approved by all members in the case of the private company. If it is going to be a public company, then the special resolution should be passed in the general meeting. Special resolution means that 75% or more of the shareholders should be actually agreeing to this particular entrenchment. So after doing this, getting the approval from all the members in the case of private company, and from the 75% or more of the members in the case of a public company, what the company has to do is they have to give the notice to the registrar of companies about this entrenchment. So this is important. This procedures have to be followed by the company. Next, let's look at the different models of articles which different companies can follow. Actually, the Companies Act 2013 has got different tables which can be followed by different types of companies. For instance, if we look at table F is the model of articles which the company limited by shares can follow. Table G can be followed by the company limited by guarantee without having the share capital. Table H can be followed by the company with a guarantee, but which has the share capital. Table I, model of article of association, can be followed by the company limited by guarantee as well as limited by shares. Unlimited company can follow the table J model of article of association. but it is not mandatory that these models have to be strictly followed by the company. They can use it as a guideline, and they can have any rules and regulations which they think that it fits the company. They can do that. Not necessarily these models have to be strictly adhered to. These models are there to give guidelines to the company in the preparation of the article of association, and whichever rules and regulation which they think that is relevant to the company and which is within the provisions of the Companies Act, they can definitely have those information in the article of association. Next, let's look at the contents of the article of association. These are all by and large the article of association of any company has these information. They can also have any other relevant information which they think that is applicable to them. First is the preliminary information. Under preliminary information, the company would be giving the details about its name, the place in which it is situated. These information would be given in the preliminary information. Under definitions and interpretations, the company would be giving definitions of the various terms that it has used in the article of association, and they will also give interpretation of various rules and regulations which they have mentioned in the article of association, because the idea is that whomsoever reads the article of association, they should understand the meaning of the rules and regulations. In order to make the understanding better, they give interpretation of the various rules and regulations which they have mentioned in the article of association. They give information about the share capital. They talk about the authorized share capital, subscribed share capital, paid up share capital of the company under this particular section. Under members, they talk about what are all the different classes of members that the company has. We have different classes of members, like we have the promoter member, foreign member, minority member. We have different classes of the members, like we have the equity share, preference share members. So the different types of members which the company has, these details would be given under this particular section. Then under this the section director, the company would be mentioning about what are all the procedures that the company follows with respect to the appointment of the director, what are all the qualifications that the director should have, what are the powers of the director, how under what conditions the directors are removed from the company. So these informations, remunerations that are paid to the director, so these informations are given under the section directors. Under dividends and reserves, the company would be talking about the policy that it would be following with respect to the declaration of the dividend. It would also be giving details about the utilization, that the kind of policy that it has with respect to the utilization of the reserves which they are going to keep from the profit that the company makes. Under general meeting, the company would be giving details about the annual general meeting, extraordinary general meeting. They would be talking about the quorum of the meeting. So these information would be provided under the general meetings. Under voting rights, the company would be talking about what are all the voting rights of different classes of members. They would also be giving details about the proxy oaths. Under borrowing powers, the company would be talking about what are all the rules and regulations which would be followed by the company with respect to the external borrowing. And they would also normally, if we look at the Companies Act 2013, no company is allowed, in fact, is allowed to borrow beyond their equity shares and reserves. In case the company wants to borrow beyond their equity shares and reserves, so what they have to do is they will have to pass a special resolution in the general meeting. So these informations would be given under borrowing powers. Under winding up, the company would be mentioning about the type of winding up that the company would be following. So normally, if we look at it, there are two types of winding up that are there. One is the voluntary winding up, another is the involuntary winding up. If we look at the voluntary winding up, means it could be the member voluntary winding up, wherein the members would be deciding to close down the company, but the members can close down the company only when the company is is not insolvent. They should be solvent. Then only they can go for the voluntary winding up by the members. So here, whenever the members wants to go for the voluntary winding up, they will have to prove that they are solvent. So only after proving that they can go ahead with the member voluntary winding up. There is one more voluntary winding up, which is called as creditors voluntary winding up. Here what happens, the creditors decide that the company should be wound up for the reason the company does not have have the capacity to pay back the loans that they have taken up from the creditors. In that case, the creditors would be making a decision, or they will pass a resolution to close down the company. There could be involuntary winding up, like where the National Company Law Tribunal would be closing down the company in order to protect the interest of the shareholders, or when the company fails to follow the rules and regulations of the Companies Act 2013, when there are violations of the rules, or when in order to protect the interest of the shareholders, the National Company Law Tribunal may ask the company to close down. So here these kinds of information would be given by the company. Then what we have is the indemnity and insurance. Normally, we all know that a company is a legal person, artificial legal person, and they cannot operate on their own. So they are distinct from their members as such. So what happens here? The directors of the company act as the agents of the company. They do all the activities on behalf of the company for the reason the company is an artificial legal person. So what happens during the course of the business activities, there are chances that the directors have to face the legal tussles and on behalf of the company as such. So in order to protect the interest of the directors, the company would be insuring the directors with respect to the legal expenses which the company has to incur. So somewhere down the line, this indemnity and insurance has an impact over the willingness of the director to act on behalf of the company, for the reason it protects their interests. There are miscellaneous provisions where here the company would be talking about the company seal. They would be talking about the appointment of directors, the qualification of the it is appointment of the auditors, the qualification of the auditors, how the auditors can be removed, the remuneration of the auditors. These information would be provided under the miscellaneous provision. So miscellaneous provision talks about the company seal as well as about the appointment, removal, qualification and remuneration of the auditors. Next, let us look at what are the procedures that are there with respect to the alteration of the Articles of Association. The article of like the memorandum of association, even the article of association can be altered. It can be changed, but there are some procedures which the company is expected to follow. One way of altering the article of association, they can make changes with respect to the rules and regulations, like we have seen the various headings, like with respect to the directors, or with respect to the voting rights, or with respect to the winding up, or whichever change that they want to make, they can make it, provided that they pass a special resolution in the general meeting. Special resolution means that 75% or more of the members should approve the change in the article of association. So basically, once 75% or it is not simple majority, it is not a normal resolution. We are talking about a special resolution wherein 75% or more of the members should be in favor of the alteration that has been made in the article of association. This is one way of altering the article of association. The next is the alteration can be done by the board of directors. This is possible only when there is a provision in the article of association where it is clearly mentioned that the board of directors are given the right to make alteration with respect to the article of association. If they are given the right, what they can do is they can bring the changes in the article of association even though the board of directors are given the power to alter the article of association, still the alterations should be ratified by the members in the general meeting. So that is needed. Next is alteration can also be done by the National Company Law Tribunal. If the National Company Law Tribunal feels that there are certain provisions in the Article of Association which is, affects the interest of a particular section of the shareholders or which affects the interest of majority of the shareholders for that matter, what they would do is they will ask the company to alter those aspects of the Article of Association. So this is also one of the way that alteration is done. And sometimes alteration can be done as per the provisions of the Article of Association, because we know, like we talk about entrenchment, wherein they want to protect that a certain alteration should not be done that easily, wherein certain protocols to be carried out by the company whenever they want to alter certain aspects of the Article of Association. So if that is the case, as per the provisions of the Article of Association, the changes can be made in the Article of Association. Next, let's look at the limitations on the powers to alter the articles. The first is with respect to the consistency with the Companies Act. Whenever any changes that are made in the Article of Association, it should be within the provisions of the Companies Act 2013. If it violates any of the provisions of the Companies Act, then such alteration is definitely not allowed. It is not only with respect to the provisions of the Companies Act 2013, whatever changes that the company makes with respect to the Article of Association, it should not be in violation of any other law that is in force in a particular country. So whatever changes that the company makes with respect to the Article of Association, it should be within the provisions of the Companies Act 2013, as well as with any other law that is in force in India. So that is one thing that should be taken care. The next is to do with contravention of Memorandum of Association. If particular change in the Article of Association is going to be against the Memorandum of Association, then such kind of change are not allowed. Let's see, like for example, if a company in its Memorandum of Association, in the object clause of the Memorandum of Association, they have mentioned that the company cannot deal with, they cannot enter into the hardware business. They have made a mention of that sort, and in the Article of Association they come with an alteration stating that the company is allowed, can enter into the computer hardware business. If such a provision is made in the Article of Association, this is totally against the object clause of the Memorandum of Association. So this kind of inconsistency is definitely not allowed. So whatever changes that are made in the Article of Association, it should be in tandem with the Memorandum of Association. It cannot be against or in contravention of the Memorandum of Association. This should be taken care. Next is about the binding effects of the contract. When we talk about the binding effects of the contract, there would have been some contracts which the company had entered before the alteration had taken place. So what happens now, because of changes that the company does in the Article of Association, there are chances the previous contracts may go null and void. And so in that case, can we say that all the previous contracts which is not consistent with the alteration that has been made in the Article of Association will be considered as null and void? No, it definitely not. All those contracts which were created based on the rules and regulations of the Article of Association before alteration will remain good even after the alteration of the Article of Association, because for the reason that all these contracts had been made before the alteration. So the company has the binding effect of the contracts which they have entered before the alteration of the Article of Association. They cannot cite the alterations and state that the contracts whatever they have entered before the alteration will become null and void. That doesn't happen. The company is responsible for all the contracts that they have made before the the alteration in the article of association. Next is about protecting the minority shareholders. Any alteration that the company does, it should not affect the interest of any of the minority shareholders. In case the alteration affects the interest of the minority shareholders, the company should get the approval from the minority shareholders, or they should get the approval from the National Company Law Tribunal. So only after getting the approval they can go ahead with those alterations which has an impact on the minority shareholders. They cannot alter the fundamental provisions. We have some fundamental provisions like the register office of the company, or we talk about the share capital, we have the voting rights, winding up of the company. These kind of changes cannot be made in the article of association, because somewhere down the line it is linked with the memorandum of association, right? We have the register situation clause, we have the object clause, we have the capital clause, so we have the liability clause. So these changes in the article of association which alters the fundamental provisions cannot be carried out by the company. That is definitely not allowed. They can also not alter anything to do with the mandatory provisions. Mandatory provisions like the appointment of the directors, qualification of the directors, remuneration of the directors, or for that matter appointment of the auditors, remuneration of the auditors, or the qualification of the auditors. So in all these cases they cannot bring changes in the article of association. So these are all some of the limitations that are there with respect to alteration of the articles of association. Next, let's look at what are the key provisions that we have with respect to the alteration of the article of association. Section 14 of the Companies Act 2013 deals with that. So whenever alteration happens in the article of association of the company, a special resolution has to be passed in the general meeting, wherein the approval of 75% or more of the members should be got. Then only this alteration is accepted, not otherwise. Next is what kind of changes that can be done. Not necessarily it should be as per the provisions that are mentioned in the Companies Act 2013. In the sense, anything that is legal that can be changed as long as it does not affect the law that is in force in the country. The changes can be made. So as long as any changes which are legal, those changes can be made in the article of association. Of course, the article of association, the changes can be made only on the condition that it does not contravene the memorandum of association. In the sense, the changes that whatever that happens in the article of association, it should be in consistence, or it should go with the memorandum of association. It cannot contravene the memorandum of association. Any changes that are made, if a particular change is made in the article of association with the objective of favoring a particular member, then such kind of changes are definitely not allowed. And if they are going to come with a change in the article of association which affects the interest of the minority shareholders, even these kinds of changes are not accepted. So they cannot come with a change in order to favor a particular member. They cannot come with a alteration which affects the interest of the minority shareholders. It is not allowed. In case they come out with the changes which affects the interest of the minority shareholders, then it should be approved by the National Company Law Tribunal. And if any of the class of member feel that it is against a member, they can always take up this particular case to the National Company Law Tribunal. Once the alteration has been done, what the company should do is, after passing a special resolution, what they have to do is they will have to submit a copy of the altered article of association to the registrar of companies within 30 days from the date of such changes that had been made in the article of association. when these changes become effective, these changes become effective from the date that has been mentioned by the registrar of the companies. From the day onwards, whatever changes that had been made by the company becomes effective. In case the tribunal feels, the National Company Law Tribunal feels that there is a violation in the changes that had been made in the Article of Association, or if they feel that the particular minority members' interests are affected, they will ask the company to go with the changes in the Article of Association. Similarly, even the registrar of companies, when he or she vets the changes, if they feel that it is against the provisions of the law in force, they will ask the company to make changes, necessary amendments in the changed Article of Association, which the company has to do. And such a rectification, once it has been done, it should be approved by the registrar of companies, and this rectification should be shown in the book of register in the registrar of companies. In case any of the directors who has done the article of changes in the Article of Association with the intention of defrauding the creditors or defrauding the members, then the directors are liable for such activities, and they will have to pay damages for the violation with respect to the changes that they have made in the Article of Association. They would be personally liable for it. Now let's look at what are all the things that should be kept in mind when the article of when there is going to be an alteration in the Article of Association with respect to a public company becoming a private company. Similarly, a private company becoming a public company. What and all that had to be altered in the Article of Association. In case a public company becomes a private company, then what change that has to be done in the Article of Association is, first thing is they have to make changes with respect to the minimum number of members, because now the public company is becoming a private company. That means minimum number of members cannot be 7, it would be 2. So they will have to remove that minimum number of members as 7, and they will have to make it as 2. It is just the other way around for a private company becoming a public company. In this case, the private company which becomes a public company should add the minimum number of members. Instead of writing that as 2, what they have to do is they will have to say the minimum number of members is 7. And with respect to right to transfer shares, the public company which becomes a private company should remove the free transferability of the shares, because now they cannot freely transfer the shares from one person to another person. So they have to remove this provision in the Article of Association. In the case of the private company becoming a public company, they have to add this right to transfer the shares freely now, because they have the right to transfer the shares freely as the private company is becoming a public company. With respect to the invitation to the public to subscribe to the shares or the debentures of the company, for a public company that is becoming a private company, they have to remove this particular provision in their Article of Association, because from now on they cannot invite the public to subscribe to the shares or buy their bonds and debentures. But the company that becomes a private company that becomes a public company, what they can do now is they can change. They can add this inviting the public to subscribe to the shares, as now they are getting the right to do so. So this change has to be made. Under these changes, after making the above mentioned changes in the Article of Association, what the company should do is they will have to pass a special resolution, and once they pass the special resolution, the same has to be approved by the National Company Law Tribunal. Then only this alteration would be valid, not otherwise. Now let us look at the difference between the Memorandum of Association and the Article of Association. If you look at Memorandum of Association talks about the scope of activities of the company, it talks about the objectives, the powers that the company has within which they can operate. But if we look at the article of association is to do with the internal management of the company, and it does not talk about the powers, it does not talk about the scope of the company activity, it talks about the rules and regulations. If we look at the contents of memorandum of association, we know like it has object clause, liability clause, registered office clause, capital clause. So it has these clauses. But if we look at the article of association deals with the internal management of the company, wherein they mention all the rules and regulations which the company would be following in order to carry out its business activities. So it talks about the different aspects. It gives the preliminary information. It talks about the voting rights, member details, winding up of the company, directors. So it talks about these things, wherein it talks about what are the different rules and regulations which the company would be following with respect to all these aspects. So the content of the memorandum of association is totally different from the article of association. The memorandum of association is about, it talks about the relationship of the company with the outsiders, because it talks about the scope of the business activities, it talks about the powers of the company. So it deals with the relationship of the company with the outsiders. But if we look at the article of association deals with the internal management. It talks about the relationship among the members of the company. It is not to do with the outsiders. So with respect to alteration of the memorandum of association is pretty tough, in the sense, in most of the cases the company has to get approval from the from the central government. They will have to get approval from the registrar of companies, regional directors. So depending on the kind of change that they are making, they have to get approval from different authorities as such. But in the case of alteration of the article of association, what they have to do is they will have to pass a special, most of the cases they will have to pass a special resolution wherein 75% or more of the shareholders members should approve the changes, and the same has to be notified to the registrar of the companies. So alteration is relatively easy with respect to article of association in comparison with the memorandum of association. The next difference is to do with the ultra-vires. This ultra-vires, anything that is done beyond the scope of the memorandum of association is considered to be ultra-vires. That becomes null and void. If the company is going to get into any activity which violates any of the clauses, any of the clauses of the memorandum of association, then it is considered to be ultra-vires, and it will be considered as null and void, and no one can ratify it, in the sense they cannot change it later. They do an activity which is ultra-vires and they cannot make it intra-vires by passing a special resolution, or they cannot do that in the case of memorandum of association. It would be considered as null and void. They cannot alter it later and pass a special resolution. This retrospective effects do not play a role in the case of memorandum of association. But in the case of article of association, let's assume the company has done something which is ultra-vires the article. What they can do is they can make it intra-vires the article by passing a special, they can alter the article of association, they can pass a special resolution, and they can make that particular act which was ultra-vires as intra-vires. This retrospective effect is possible in the case of article of association. Now let us look at the binding effects of article of association. If you look at the article of association talks about article contract, unlike a normal natural contract. Normally whenever any contract is made between two people, what happens is both the parties would be present at the time of the formation of the contract. So both of them would be knowing about the contents of the contract. But in the case of article of association is a type of contract with the members as such. But the members, not necessarily all the members would be there at the time of the inception of the company, because article of association is getting created at the time of the formation of the company itself. So there would be members who would be joining at a later stage after the commencement of the business. Even though they join after the commencement of the business, they are still bound to the rules and regulations that have been specified in the article of association. That is what we call it as article contract. So it doesn't, it is unlike a natural contract, though the members, some of the members who wouldn't have been part of the contract of article at the time of its creation, they are still bound by all the rules and regulations that have been specified in the article once they become the member of the company. So first is about members bound to the company and vice versa. Members are bound to the company as well as the company is bound to the members. Both of them are expected to follow the rules and regulations. That's very important. Now we are going to look at enforcement of the article contract by a member against the company. We can understand this particular aspect by looking at the case between Wood and Odisha Waterworks Corporation. In this case, the petitioner felt that the company went for changing the dividend declaration pattern. As per the article of association, the company have to get approval from the shareholders before they go for the declaration of the dividend, and they cannot. And what the company did here was the company changed the dividend pattern, in the sense they wanted to convert the payment of dividend into debentures, and they got the approval from the general meeting, and they went ahead with converting the dividend into the debenture bonds to the members. So what Mr. Wood did was he filed a case against the company on behalf of other members too, stating that the company must have got approval from the members in the general meeting with respect to the declaration of dividend, but instead they changed the dividend into debenture bonds. If you look at the judgment was in favor of the petitioner, Mr. Wood, because as per the rules and regulations of the article of association, the company must have got the approval with respect to the declaration of dividend, but instead they didn't even take up that matter in the general meeting. Instead, they got the approval of converting the dividend payment into debenture bonds, which is against the rules and against the provisions of the article of association, and which they are not supposed to do. Here the company was made bound to the members, and this violation of rules and regulation was not accepted. Next is about binding between the members. It is not only that the article of association creates the binding bond between the company and the members, it also creates a bond among the members. And all the members should follow the rules and regulations as per the article of association. This can be understood better by looking at the case between Rayfield versus Hans. This is with respect to the enforcement of the article contract by the member against other members. As per the article of association, if at all a member wants to sell the shares of the company, they are not supposed to sell it to the outsiders. They can either sell it to the director member, or they can sell it to a member who is willing to pay a fair price to the particular share. Here Mr. Rayfield tried selling his share to the members, but none of the members were willing to buy it. So what he couldn't exit the company, because he is not supposed to sell the shares to outsiders as per the articles of association. So here what he did, he went to the court, and the court felt that every member is bound to to another member with respect to the selling of the shares. No one can refuse getting the shares since one of the members wants to exit, and it should be bought by one of the members, as the members are not allowed to sell the shares outside the company. So here it is a case of binding of the article of association among the members. But the article of association do not bind the company to the outsiders. Though, because it binds only the company to the members, it binds all the members together, but there is no binding between the company and the outsiders. We can understand this better by looking at the case between LA versus Positive Government Security Life Insurance Corporation. In this particular case, the company was having a provision in the article of association that the solicitor of the company cannot be sacked unless and until there is a kind of fraudulent or if the solicitor is going to involve in any kind of unlawful activities. Only if the solicitor involves in any unlawful activities, the solicitor can be sacked. Otherwise, the solicitor has to be kept in service. This was the provision that was there in the article of association. Mr. LA was the solicitor of the company, but what the company did was, Mr. LA did not involve himself in any kind of unlawful activities as such. And but what the company did was, the company sacked Mr. LA from the post of the solicitor. So Mr. LA went to the court stating that as per the article of association, the solicitor cannot be sacked unless the solicitor involves himself or herself with unlawful activities, and he was telling like he was not involved in any of it, still he was sacked. But if you look at the judgment, the judgment was in favor of the company because it was felt by the court that though it is mentioned in the article of association, this does not bind the company with the outsider, because solicitor is an outsider, he is not the member of the company. So though this has been mentioned in the article of association, the solicitor cannot be sacked unless he gets into any kind of unlawful activities. Though it has been told like that, this cannot be used by the solicitor when he got sacked, because he is an outsider. The company does not have any kind of binding with the outsider with respect to the rules and regulations that the company has stated in the article of association. Thanks for listening.